I will recognize Vice Chair Ferguson for purposes of an amendment.
Yes, I motion to amend with Amendment 136_1125, which you can see there on your iPad.
The memo was also sent out yesterday and this morning. Would you please explain the amendment?
Yes, so as you can check here in the synopsis, it talks about restrictions on delegate communications. It was brought forth by the sponsors of the bill, Rep. McLean and Rep. Willis, but it just removes a provision of the bill that prohibit a convention delegate from doing either of the following, which is communicating the impression to any person outside the delegation that the delegation is divided on the question. Again, that was brought forth by the sponsors.
Is there objection to the amendment? Hearing no objection, the amendment will now be a part of the bill. We will now call up for in-person testimony, Mr. Michael Farris. Good morning, Mr. Farris. I believe you were with us. I was looking at my notes here, May 20th of 2025, just a few months ago. Is it the same testimony? I was looking through your testimony, or was there anything you'd like to add to that?
Mr. Chairman, Ranking Member, Vice Chairman, thank you for the opportunity to be here. No, I really don't have anything to add, but if you have any questions about this, I would just say 16 states have adopted measures just like this, or in the same nature. They vary from state to state to some degree. But the idea of making sure that delegates follow the intention of the convention, stay on track, don't go outside the realm, is gaining popularity in this country, is a responsible thing that states need to do to make sure that their delegates perform their duties. With that, I have nothing else, Your Honor.
Okay. Well, thank you, Mr. Farris. Again, I wanted to give you the opportunity. I just was trying to make it easier on you by not having to go through that testimony again for us today. Representative Rita has a question for you.
Thank you, Mr. Farris, for being here, and it would be a waste of you to come all the way this way without me asking at least one question. So happy to, and in fact, it'll be the same question. I believe I asked you, I might have asked the sponsor of this. It's been a while, a couple of months. But as it pertains to how we select the delegates, I just feel like this isn't giving any real teeth to any reason why the majority would include any minority voices in this mix. We represent several million people in the state as the minority. Why wouldn't, and maybe, in the future, the minority may be the other party, who knows, right? So why wouldn't the minority have some, first off, maybe you can clarify, maybe I'm wrong, is the minority sort of included in the language of this so that there's at least a seat at the table for the folks on the other side of the aisle? Or do we need to perhaps include something in here to make sure there's a mechanism that the minority voices in the state are represented?
Representative Rita, through the chairman, the bill is silent on this issue. The general or the legislature is free to choose whoever you wish. If you want to have a politically divided group, you can do that. If you want it to be all one kind, you can do it. You don't even have to use members of the legislature to be a part of it. It could just be ordinary citizens who express interest or expertise or other things. And so that would be for the decision of that point in time. As it sits right now, you could specify that you'd have to come up with a fairly complex mechanism that here to date no state has done, that would say, the majority party gets to nominate X number, the minority party gets to nominate X number. That's a mechanism that would allow you to do it, but that would be up to this body to figure that out. And so far, I think that would be a negotiation that would make more sense to me, at least, at the time you're actually appointing the people, as opposed to trying to figure it out in advance, because there could be some things that just aren't that controversial. Like, for example, a measure that did nothing more than saying there are only 9 justices on the Supreme Court of the United States. That there could be a convention on that to stop the possibility of court packing. And if that was one of the ones, I don't see that there would be a need for a partisan divide on that. You could just appoint some people that know about that issue and send them off. And so I think that would be perhaps better addressed convention by convention, depending on the subject matter.
Thank you. Thank you, Mr. Chair. Just that, I appreciate that. Thank you for the response.
Yeah.
I do feel like without some mechanism, I'm just worried that the voices of several million Ohioans will be shut out of this process. That's all. So I do appreciate the response. No need to respond to that. Thank you, Mr. Chair.
Any other questions? Representative Sims.
Thank you, Mr. Chairman. Thank you again for being here. So you said 16 states have adopted a similar amendment.
Yes.
So just out of curiosity, is there any penalties for running afoul of?
Mr. Chairman, Representative, some states, yes. Some states it's a criminal act. Some it's a misdemeanor. The couple there's a felony. Others that are you can just be removed from your commission. There's a variety of penalties that have been adopted. Some are more aggressive than others. And to me, the state gets to choose that. I'm not as dead set on any one particular way of doing it. I do like the idea very much that the legislature stays in charge and makes sure the delegates stay on track and don't mess up. And if they do, there's power to act to make sure that they come back in the fold, or else they go away. And so the mechanisms that you use, there's a variety of ways that can make that work. And so I don't think that there's a magical formula in all 16 that would give you the answer.
Follow-up?
So just in case, just
Yeah.
hypothetically, you have a magical formula. What would that be for you? This seems really important to you.
Well, I think that the principle is important that excuse me, Mr. Chairman, Representative, the principle is very important that the legislature maintain control. Whether that's a Class 1 misdemeanor or a Class 2 misdemeanor, depending on the terminology in your state, I'm indifferent to that. I think that the ability to enforce with real power will be important, potentially. It's something that the people know that are in place, that they can't go running off the reservation and start trying to turn the convention into something it's not supposed to be about. It's supposed to be about topic X. If you go to topic Y, you're going to be in trouble. And I think that principle, I'm very, very strong on that principle. The mechanisms, whether one's preferable to the other, that's really a state preference. And as a national person for the Convention States Project, I don't express a strong view on which exact methodology that you use. And as long as you remove them, I mean, to me, that's the minimum, that you have the power to instantaneously remove them upon due notice. I think that's extremely important and should be a part of it on any bill of this nature.
Thank you, Mr. Chairman. Thank you.
Any other question? Representative Workman.
Thank you, Chair. Thank you, Dr. Farris, for being here. I think the last time you were here, I was not able to be, so it's a pleasure. I highly appreciate the many victories you've had at all levels of government. Thank you so much for the work that you've done. But more importantly, from my perspective, is the vision that you have for what could be for a better community, better state government, better national government, in a better world. So for that, I thank you. But I do have some concerns and questions specifically related to the state's responsibility to recall delegates if they are out of hand. What happens if the state decides to wash their hands of the process and disengage from their responsibility?
Mr. Chairman, Representative Workman, I would hope that that would never be the case of any state, and particularly the state of Ohio, that you would disengage and walk away from responsibilities. Obviously, it raises the potential that a delegate could abuse their authority. Now, would that be a material problem in any sense? Would the delegate, the disobedient delegate, be able to switch the delegation? Because at any convention of this nature, it's one state, one vote. And so as long as the majority are staying faithful, the state's not going to be misrepresented at the convention. Now, if you have a problem so that there are more than a majority that are going off the rails, you've got a real problem at that point in time. And so, choosing carefully, I think, obviously is very important. To me, the chances of a majority of any delegation being willing to disregard the instructions from their state, from the call of the convention and so on, and their honor and duty as a citizen of this country that loves their country, I think the chances of majority going off the rails in that fashion is so low as to be essentially inconsequential. Individuals can cause problems, and the ability of a state to call them back, I think, is important. But if they just decided to all go on vacation and just ignore it, I think the consequences are more of an agitation as opposed to a real crisis.
Follow-up, Chair?
Absolutely.
Thank you. I appreciate that response. Thank you. So if I've learned anything in the political arena, is that absolute power corrupts absolutely. That's something that I have experienced firsthand. So I guess, again, you know, this is a process that we put extreme deliberation into, and I understand the importance of the state's role in this, but my concern, again, is that the state may disregard that responsibility. So I appreciate your time. You know, I'm still thinking about where I am on this and where we go from here, but it is always helpful to have these respectful debates and discussions. So thank you very much. And thank you for everyone else that's here with us today.
Thank you.
Thank you, Representative Workman. Ranking Member Humphrey.
Thank you, Mr. Chairman, and thank you, Ms. Farris, for being here. It's always good to see you. I have a question about delegate selection and then just oversight. So, and this might have been asked the last time you were here, but I'm going to ask it again. Do you know what the reasoning was behind specifying an odd number of delegates? Do you think it was to simply kind of prevent tie votes, or do you think it was just to intend to reflect the precedent in other states?
Mr. Chairman, Representative Humphrey, it's simply to prevent tie votes. That's it, is that you vote as a state, and you don't want to be in a position where Ohio's vote doesn't count because you reach a tie. And so having, whether it's 3, 5, 7, or 9, and I would recommend strongly that you pick one of those numbers and not 37 or 41, is that you just don't want to have ties. You want to be able to get stuff done and get Ohio's vote on the record.
Any other questions from members of the committee? Seeing none, Mr. Farris, stay right there. That will conclude this third hearing for House Bill 67. Going to call forth House Joint Resolution number 2 for its third hearing. Mr. Farris, is there any remarks you would like to provide for the House Joint Resolution? And then obviously take questions from members of the committee.
Mr. Chairman, Ranking Member, Representative Humphrey, and Vice Chairman Ferguson, thank you so much for the opportunity to be here. Again, I've passed out to all of y'all a law review article written by Governor Greg Abbott, who before he was governor was the Attorney General of Texas. That is, I just actually, even though I've been on this mission for over a decade now, I didn't see this article until yesterday. It is a thorough examination of the theory of a runaway convention, among other things, and it's a very good law review article published in one of the University of Texas Law Reviews that gives a thorough answer to the runaway convention argument and other things, and I thought I would just pass that on for your consideration. The only other thing I would like to say today before taking questions is, to the best of my recollection, I've been coming here since 2015. It could have been 2016, but it was either 15 or 16. And the national debt in 2015 was $18 trillion. The national debt in 2016 was $19 trillion. Today, the national debt is $38 trillion and climbing. We've effectively doubled in the period of time that Ohio's been thinking about this. Now, obviously, the people who are sitting here have largely changed in that period of time, and so the individuals have changed, and that matters. But nonetheless, we've been talking about this for a very long time. And one of the key things that the Convention of States seeks to stop is the runaway federal spending and debt. That's got to change. It's not going to change from the inside. We have seen way too much evidence that no matter who's in power, no matter what party's in control, the runaway expenditures of our country and the deepening of debt is going deeper and deeper into trouble. I would note that since I've been coming, I not only added a bunch of grandkids, but I'm now a great-grandfather. And I'm concerned about the legacy that we're leaving our kids and our grandkids, and to my case, my great-grandchildren. The debt is going to be at a point where it's crippling. We are denying these kids the benefit of the principle of no taxation without representation, because the taxes are imposed once the spending is made. You have to pay the bill. You got to raise the taxes. And so the discretion is gone. The ability to vote the rascals out who are spending the money, it disappears for the kids in the future. And it's at a level, it's not a noise factor. It is going to be the dominant feature of federal spending is paying the debt. It's already very large feature, but it's going to be a majority before long. And we simply need to do something. And my respectful request is this. We've talked about it long enough in Ohio. Please, let's get this done.
Well, thank you for those comments, and thank you for submitting the article. I have not read it yet, to be very honest with you, but happy to look through it today and tomorrow. Are there any questions from members of the committee? Seeing none, Mr. Farris, thank you again for all your insights on both HCR number 2 and House Bill 67 today.
Thank you, Mr. Chairman.
I would now call forth William Geraci. I apologize if I,
Mr. Chairman,
yeah,
if you were Italian, you'd hold your hands up like
yes, yes,
and you'd say, William Geraci.
you're right. Well, we have Senator Catrona over in the Senate. He'd be happy to indulge.
Just as a side note, my great-grandfather, Salvatore Geraci, came from Sicily in the late 1800s on a boat from Genoa. And so 16 years old, coming to the United States, doesn't speak a lick of English. But when he gets here, he changes his name from Salvatore Geraci to Charlie Geraci. Go figure.
Okay, sounds like I watched that movie in The Godfather. Welcome to committee. You may begin when ready.
Thank you so much. And thank you all for having this hearing again. It's just so incredible to see our government at work, especially at the state level. And it's really an honor and a privilege to be able to just share with you a few minutes about my perspective of House Bill or House Joint Resolution 2. As we've already said, my name is Bill Geraci. I own an insurance agency in Sunbury, and that's in House District 61. I specialize in selling health insurance to employers, and I've been doing that for 24 years, selling health insurance. So as I say in my paper, when I sit down with an employer, especially at this time of the year, because this is the time when most employers are renewing their health insurance, January the 1st. So the last quarter of the year, I'm constantly meeting with employers about their health insurance and the cost of it. And again, these are employers that are providing benefits to their employees. And when I'm sitting in that room going through the proposals and the ideas and strategies, always kind of behind my shoulder is the ghost of Washington, D.C. And as I say here, they're silent, they're invisible, and expensive. Now, this is a crazy number, but I say that about 15% of the premium for an employer is spent in federal regulations to, as I say in the below, we've got 4 federal departments that are constantly passing regulations and asking for fees and things like that. And so about 15%, so if you were looking at a small employer that had 50 employees, they'd be easily spending $500,000 a year on their benefits. And I don't know if you see the trend in health insurance, but right now they're predicting that the premiums on the Affordable Care Act, or Obamacare, it's going to go up over 30% this year. Can you imagine that? And if you're an employer trying to provide that kind of benefit, how do you take care of that? Well, my goal is to deal with that 15% that has to do with the federal government being involved in it. And as I said, the money doesn't buy care. It doesn't buy care. What it buys is it funds paperwork, it funds fees, it funds the federal bureaucracy. And the quiet price of providing obedience to a system that forgot who pays the bills. That's not health care. That's not health insurance. That's control disguised as protection. And as I said, Health and Human Services, the Department of Labor, the IRS, and CMS have layered rule upon rule. To a small employer in Lima or Chillicothe, it's not oversight, it's overreach. So again, as I said, for a small employer, $50,000 a year in compliance costs, $50,000. That means it's a person that they might have hired but didn't, because that money's went to the federal government. And it could be raises, it could be a new piece of equipment, but they can't do that because they've paid that $50,000 or 10 to 15% to the federal government for just what the federal government does. And as I said, Ohio has always led with local solutions. We built hospitals, trained nurses long before Washington wrote its first regulation. When care decisions stay close to home, they're faster, they're cheaper, and more humane. So this isn't about an ideology, it's about ownership. Who governs the cost of health care insurance for Ohio families? Our founders designed a balance between the federal and state authority to protect the citizens from a distant control. That's federalism, keeping governance close to the people it serves. And across the country, leaders are re-examining that balance. An Article 5 state-led convention to propose limited amendments is the constitutional tool the founders gave for us to restore this. Because when states control, not the federal government, families afford, and that's a key word, they can afford what they need. So I asked the committee to recognize the cost of this drift and have the courage to ask the constitutional question, where should the line of authority be drawn? Because freedom isn't granted by paperwork, it's protected by principles. And transparency isn't rebellion, it's leadership. So I respectfully ask you to pass House Joint Resolution 2. Thank you so much.
Thank you for coming in today, and thank you for your testimony. Is there any questions from members of the committee? Vice Chair Ferguson.
Thank you for coming in today. Always appreciate people coming in to testify. It does make a difference, and we appreciate you being here. Mine's really just more a statement in response to what you have in your testimony here, and it just says, I mean, you asked the question, where should the line of authority be drawn? And you mentioned it as a constitutional question, but I will point out to the committee, it predates the Constitution. This is actually a question within the Declaration of Independence, and where is that line of authority? And it very clearly states, I have it here, that governments are instituted among men, deriving their just powers from the consent of the governed. Then it says, and this is very much to the call of a convention, and this is why I think our founders placed into the Constitution, that why they placed the ability to call a convention. The very next line of the Declaration of Independence says that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. Well, if it's the right of the people to alter their government, there has to be a mechanism for the people to do so, not simply just, their elected officials. And this is one of those many mechanisms that they placed forward in there. So I just wanted to really point that out to you and say, I think that we should even look a step before the Constitution to look at our Declaration of Independence and the way that our forefathers laid things out for us.
Excellent. Thank you, sir.
Thank you, Vice Chair Ferguson and Representative Workman.
Thank you, Chair. Mr. Geraci.
Hey.
Thank you for your testimony today. So you're from Ohio, correct?
Correct.
Okay, thank you. So my question, I guess, is related to the outcomes. Let's say, for example, that we hold a convention, and those 3 subject matters are actually addressed at the convention, and power is returned back to the states. For example, the Department of Education is returned back to the responsibility of the state. We just kind of went through something similar to this whenever we had the reversal of Roe v. Wade. And Ohio had a ballot initiative funded by foreign influence and foreign dollars to make Ohio an abortion-on-demand state. So that's what won, and we today are an abortion-on-demand state. My concern and worry, I guess, is what prevents outside influences from filling the void, right? Whenever these responsibilities are returned back to the states. What are your thoughts on that? I'm curious. Thank you.
Well, thank you, Chairman Hall, Representative Workman. That's a great question. And as I say, I deal with this every day because, for instance, I think most of us might know that one of the biggest contributors to our federal government is Big Pharma. So your concern about influences at a state level are already happening at the federal level. We have no control over that, but I believe that if that influence is, if we can bring that decision-making here to our state house, we have a better chance of being able to monitor that. And again, your concern is about amendments. I'm just talking about the practical regulations that would be passed by the House and the Senate here in Ohio. And then again, just being able to monitor who's doing the influence and properly monitor that.
Follow-up, Chair?
Absolutely.
I'll make it quick, thank you. Appreciate that. So I guess the main concern is, again, the void that's left when the responsibility is returned to the state if they're unprepared or they don't have the ability to fund issues like what we just went through with abortion on demand. So happy to hear anything else you might say on that front and appreciate your being here today.
Oh, well, again, thank you, Chairman Hall and Representative Workman. So as it relates to those amendatory, the amendments being passed, again, I'm not looking at that per se. I'm really looking at the regulations that are being required by businesses on a daily basis as it relates to how much of that premium that they're paying is going for the real cause, and that's to cover the cost of health care. So could those decisions here at the representative level happen with influences? Certainly, they do. I think that's, I think would be all naive if we didn't know that people like me would be coming into your offices and talking about particular bills and things like that to consider for the cost of health care, health insurance. So we're doing the right thing. But again, I can't speak to that from a amendment perspective. That's the voice of the people. And, unfortunately, like you said, some of that is funded by outside monies or monies that we may not necessarily agree with, depending on our political persuasion or our position on a particular amendment. But what I want to do is be able to sit down and talk with you about a piece of legislation or a regulation that could impact the employers here in the state of Ohio. And again, it always is the trickle down, and it's the thing that I hate the most, is that it goes from the insurance companies down to the employer and ultimately to that employee. Because it's so expensive, employers have no choice but to pass it on to the employee. And most people don't know this, but the number one cause of personal bankruptcy in the United States right now is medical debt, right? And so my passion is to try to prevent that from happening. And I think it's most effective here with you all at our State House.
Any other questions from members of the committee? Seeing none, thank you for coming in today and thank you for your testimony.
I have one last question. Say my last name.
Geraci.
All right, thank you.
I will now call for Virginia Morgan for testimony. Good morning.
Good morning. Chair Hall, Vice Chair Ferguson, and Ranking Member Humphrey. Earlier this month, I visited historic colonial Williamsburg, Virginia, a dream vacation for me as an amateur historian. Steeped in Williamsburg's living history, I ask myself what position I would have taken in the colonies 250 years ago in 1776. Would I have been a patriot? Or would my fear of the British Army have kept me silent to avoid arrest if I spoke out in favor of independence? The political climate in 1776 was not so different from today, with elites exerting power over people they presumed less valuable. Massachusetts had responded to England with the Boston Tea Party. Today, Americans do not want to see, for one, our money so poorly managed by either party. Our advantage over the colonists is we can look to our bylaws for guidance, to our Constitution's Article 5 inserted by our founders. The process works within the framework of the Constitution as a way to course correct the imbalance of power among the states and DC. Our founding documents affirmed government's principal duty as upholding the basic tenets of individual freedoms and the natural limit to government intrusion in the daily lives of our citizens. Article 5 can ensure it. You are in a position of great power. I urge you to recognize the value in the novel tool we bring before you and allow with confidence for Ohio to be the 20th state to pass the COS resolution. Answerable to the American people and to the law, appointed commissioners will, I believe, do the right thing in convention. I believe it is likely that I would have been a brave patriot in favor of independence in 1776. I reflect on the heroic patriot Nathan Hale, who said, "I regret that I have only one life to give for my country." While I am not facing a noose, as he was, nature has me in the twilight of my life, too, and I regret that I won't be able much longer to push on in this fight for freedom. And so I appeal to you, the statespeople of our time, here in this august and powerful body, to do your duty in helping solve our country's most pressing problems. The scale of justice balances itself. It's the way of nature and of nature's God. Be brave, I implore you, and do the bold thing, as so many others have done in our country's history when citizen rights were threatened and the ship of state needed to be righted. I implore you, please pass HJR 2 out of this committee, and I thank you for your service.
Thank you for your testimony this morning. Are there questions from members of the committee? Seeing none, thank you for being with us this morning. That will conclude, or is there anyone else here to testify on HJR number 2? Seeing none, that will conclude the third hearing on HJR number 2. Seeing no further items on the agenda, the House Government Oversight Committee stands adjourned.
Hello, everyone. You have been watching a hearing of the Ohio House Government Oversight Committee. This was the third hearing that Convention of States has had in this. Oops, sorry about that. Let me just try to adjust. There we go. Try to get a little bit better focus on my camera there. Yeah, this was the third hearing we've had, and today the hearing covered both our Article 5 application on the House side, which you heard referred to as HJR 2, also covered our 34 ready legislation pending in the Ohio House, which is HB 67. Now, originally, this was slated to be a hearing for both opponent testimony and proponent testimony. We have already had a full hearing that was only proponent testimony. That was the second hearing. First hearing was the sponsor's introduction of this bill and resolution. We found out just yesterday that the plan was being changed in the committee. They weren't going to slate opponent testimony for today, where it would be a joint thing, which is what we had expected. We think it might have had something to do with the fact that Representative Jennifer Gross was absent today. She is an opponent of these bills. Maybe she wanted a chance to be there when the opponents came to testify. I don't know. That's just speculation. But at any rate, the hearing for the proponents went forward today as planned, and we got to hear from our very own Michael Farris, of course, co-founder and senior advisor for Convention of States Action. So it was great to have him there to testify again. You could tell the committee members really responded to him and appreciated him being there. And I want to mention before I go any further that the other thing happening in Columbus at the Ohio State Capitol today is our grassroots team is having a rally right now outside the Capitol. Michael Farris has probably already left the hearing room to speak at that rally, and of course our state director Bill Scott, and as well as some of our sponsors, I believe, are going to be speaking at that rally today. So I'm hoping they're having a great rally. Unfortunately, that means we probably won't get to hear from State Director Bill Scott or Regional Director Dale Tipton, since they are out there doing a rally, but I hope they have a good turnout today. It was a short hearing. The committee did hear, again, HJR 2, our Convention of States application, as well as HB 67, our 34 ready bill in Ohio. They started with HB 67, the 34 ready bill. And for those of you who aren't familiar with our phrase 34 ready, it basically is legislation that sets out the actual procedures that the state of Ohio would use once a convention of the states is called. So it sets out how the state legislature would go about choosing the commissioners that then go and represent Ohio at the convention for proposing amendments. It also talks about how the legislature will oversee what they're doing when they're at the convention, sets forth the qualifications in order to become a commissioner, and the process for recalling a commissioner who maybe does something they're not authorized to do at the convention. All of that is governed by this legislation that in Ohio is HB 67. The hearing on that bill started with a friendly amendment that was adopted to correct a concern that one of the committee members expressed with regard to the bill. It was kind of just a technical correction, and of course our sponsors were completely supportive of that, so that amendment was adopted without objection. Then, after a couple of short questions on that bill, the committee moved on to HJR 2, our Convention of States application. This is the same application that 19 states have already passed. It's applying to Congress pursuant to Article 5 of the Constitution for a convention to propose constitutional amendments on 3 topics: imposing fiscal restraints on the federal government, limiting its power and jurisdiction, and setting term limits for federal officials and members of Congress. Those 3 topics define the scope and the limitation of what can be considered and proposed at an Article 5 convention once 34 states pass this same application. So Ohio, again, is well on its way in this process. This was the third hearing on the House side. The Senate has already had 3 hearings as well, but we haven't had a vote yet. The good news is, in Ohio, their legislative session will continue into 2026. So we still have plenty of time to get this done during this session of the Ohio legislature, although it looks like that wouldn't happen at this point until 2026. We're hoping for early in 2026. We would love to see Ohio become state number 20 to apply for a convention by passing the COS resolution. Now, Mike was first up, Mike Farris, to testify in favor of HJR2, our COS application there. And he kept his testimony short, which was really wise in this situation since he's already been there to testify on this same resolution in front of this same committee. So he kept it really short and he focused on the national debt. He pointed out that the national debt has doubled, is now at $38 trillion, which is a doubling since Ohio started considering this COS application. They have been considering the COS application session after session since 2016. And so Mike wanted to point out that the delay in more states passing the application so we can get to 34 states and get to convention is costly. It is allowing Congress to just continue to ratchet up the national debt to an unconscionable level. I thought that was a great strategy that Mike used. He sort of closed by saying, we've talked about it long enough in Ohio. And if you're like me and have been watching Ohio hold all these committee hearings year after year, I am sure you wholeheartedly agree with Mike's assessment there. We next heard from William, the pronunciation of the name, I don't know if I can get it right, William Geraci, an Italian who spoke a little bit about his Italian heritage, was very moving, and he had just a delightful affect. He was gracious, he was grateful, he was appreciative. And he talked from his area of expertise, which is health insurance. He sells health insurance policies to employers. And he pointed out that 15% of the premiums that are being paid for these health insurance policies so that employees have health insurance coverage, 15% of those premiums are going just to fund the federal bureaucracy. That's a big deal, and I thought that was a really persuasive and great point. I love that he drew upon his just personal area of expertise and experience in dealing with federal bureaucracy and government overreach. He did a great job. Then we heard from Virginia Morgan, and she talked about the courage to be a patriot. She asked the question, would I have had the courage to be a patriot during the Revolutionary period? And she ended by concluding that she would. And so it was really a timely sort of gentle challenge to these committee members. It's time to do something. It's time to push this cause forward and support this Convention of States application. So that's what happened in the committee hearing. They did not vote. We were not expecting them to vote, but we do hope that that vote will happen soon. At this point, of course, there will have to be at least one more hearing by this Ohio House Government Oversight Committee because, again, they haven't yet heard from the opponents. So we will definitely be bringing you coverage of that hearing when it gets scheduled. Stay tuned, stay plugged in, and we'll let you know when that's happening so you can be sure to watch. That's going to be a hard one to stomach. It always is, but we will do what we can to respond to the various allegations made out of either dishonesty or ignorance against the Article 5 process. So again, stay tuned for that. We appreciate you joining us today. I'm Rita Peters, signing off.